Good afternoon, Your Honor. Constable based on behalf of Mr. McFall, who is present to my right. You state your full name.
This is not a routine hearing. It's a probable cause conference, and bond is at risk. If the judge finds repeated violations, custody becomes a real possibility.
For the record, please.
Floyd McFall.
Your Honor, today is the date and time set for PCC. At this time, we're going to be requesting to set this for an exam.
Discovery is complete.
To my knowledge, yes.
People have their witnesses available on the 9th.
Yes, Your Honor.
Preliminary examination in person, September 9th, 2025, 9 a.m. That's before
Judge Malvo.
Judge Valvo. We've got, you want to address the violations now?
Yes, Your Honor. I did speak with my client about the violation. He did attempt to turn himself in twice, and he was told that there was no warrant. Him and I spoke about it in depth. He understands how serious it is. Your Honor, if the court is willing, maybe to put him on a...
When multiple violations appear across different dates, courts stop seeing isolated mistakes. They start seeing a pattern of non-compliance.
SCRAM Tether, and he will have no further violations in this matter. He's just asking for one more chance, Your Honor.
Response from the people?
Your Honor, we have concerns about involved like I would note that it's not just one incident, it's on two different days, and that the report indicates that when Mr. McFall was questioned about the August 19th date, he admitted drinking, but then we have an August 24th date. So,
And also an August 26th date. It's on, that was, you may not have, well, you should have. There was one report on August 20th, which has those two on it, I think. Maybe not. No, the 19th, and then he drank on the 24th, but then further down.
In bond court, failing to test and refusing or missing a follow-up can carry nearly the same weight. Compliance must be consistent.
He also then blew and numbers on the 26th. But there aren't any other readings because he didn't take the follow-up test.
and so, Your Honor, part of the reason that we find it concerning, believe that alcohol may get involved with this, and that as far as the felonious assault charge, the alleged weapon is a wine bottle. So that's what gives us some concern. So I don't see why an alcohol tether is going to somehow ensure that Mr. McFall applies with bond conditions that he seems to violate it multiple times when he was confronted.
Well, Your Honor, in response, although a wine bottle is allegedly involved, that's because these allegations took place at a store. He was not drinking at the time. There was no, I don't believe there was an alcohol test taken at the time of arrest. So there's not really a substance abuse problem involved. And I would say that the tether would be a constant reminder that if he does end up drinking, he's going to be remanded.
So blowing into a machine doesn't do that?
Well, Your Honor, I think the tether on his leg is and I've had serious conversations with him, Your Honor. He's just asking for one more chance. He is here today. He understood that there was a warrant for his arrest. He still came in. He did try to turn himself in a couple days ago when I originally told him that there was no bond warrant. He does want to move forward, Your Honor. He's just asking for another chance.
3 occasions. Is he in any treatment or anything at this point?
No. Just at my church. I don't have.
And with that decision, the court revokes bond. No extended debate, just enforcement of prior conditions.
Before though, and I did sign up for AA. I took like a hour-long test on it. I just got to get into.
Okay. Well, it looks like he is working on that, Your Honor. He's signed up.
Working on it.
Yes, he's signed up for treatment.
Between drinks. Bond revoked. Defendant's remanded.
That's good.